I'm not standing in the way, my lord. I'm ready to pay the, my lord, the bond amount. That is also reflected in my resignation letter.
Where is the provision of 3 months?
My lord, your lordship takes a rule 34 WBSR part 1, my lord, rule 34. And your lordship has quoted in your lordship's order even. That is also annexed.
Huh?
34 has been amended.
My lord, that is with regard to anybody who has rendered less than 5 years of service. My lord, in my case, that is not the issue, my lord. I am rendered more than, my lord, 8 years, 9 years of service.
Proceeding has been completed.
Huh?
Before resignation, proceeding has been completed.
But there is no proceeding initiated against me, my lord.
Rule 34.
Rule 34, my lord,
WBSR.
Rule 34, my lord, WBSR Rule 34A1. My lord, your lordship may takes up your lordship's order, entire rule has been quoted. Page 69. Page 69, my lord, paragraph 10, the entire rule has been quoted, my lord. Even the note part, but I'm banking on, my lord, if your lordship takes up. Next page. Uh, 34A2 is the, my lord, the forfeiture part. Paragraph 12, my lord, your lordship has clarified the rule even to the extent possible, my lord.
Yes, you take a decision.
We shall have to take a final decision on page 55.
Hmm?
Page 55. We shall have to take decision on the page 55.
No, yes, give. It is not a allegation of anything. It is just that after resignation, he is not attending. It's not prior to the date of resignation.
And he was selected in a postgraduate course in a state government quota. And given a bond, he will serve the government at least for 5 years. If he fails to do so, he will pay 30 lakhs.
15 lakhs.
Not a problem.
So that is a consequence.
That is the consequence.
No other consequence.
Not a problem. But why the government has it? Per student, AMS, 30 lakhs per student, government has to spend.
That's why he is paying 15 lakhs. He says he is paying 15 lakhs. He is also paying you the salary for the entire period. He will not get any pension. Get rid of him. There is no allegation. It is his what unauthorized. He is resigned. Why he should attend the duty?
Until unless resignation is accepted.
If not accepted, you will. How can you not accept?
No,
There is no reason for not accepting. You have to accept. Unless you come up with a reason that prior to the date of resignation, there was some proceeding pending, there was some allegation, there was some loan, something of that kind, you have to accept. You can't, there is no discretion to reject. There is only a condition under which it can be rejected. Otherwise, it cannot be rejected.
Let him reply to this notice and government will directly.
Why he should reply? We will take care of that. That's nothing. That means nothing. After resignation, why he should attend the office?
Resignation, madam.
See, there is a opportunity to you to pass an adverse order within 3 months. If you don't pass an order, then deemed acceptance of resignation. You read the provision. You read what it says. Unless the government otherwise directs. So if you don't otherwise direct, it is deemed acceptance, and rightly so. Because there is no option otherwise. You have to accept. You can only otherwise direct if those circumstances exist. If they don't exist, you have no discretion. You have no discretion. Correct. So therefore, the rule itself contemplates for this 3 month, either he can pay the salary and leave immediately, or he can serve for the 3 months. This cannot constitute a misconduct.
No. Answer the absence is a mistake.
He is saying he will give all the money. He is willing to pay back whatever salary has been credited. He will give you the 15 lakhs, everything. So then you can't hold back on, you can't hold him back. Therefore, we are saying take an instruction. Third learned advocate for the parties. 27th April. Yes. Something like that. That I have spent UP. Willing. Otherwise, there's something like why don't they have acquired this proficiency to serve the you have to learn from these. That should be we don't have such a big sustain on yes, sir.
I beg to appear for the petition, my lord. This is that matter whereby the Honorable Supreme Court has requested your lordships to take up the appeal once again, my lord. Once again, freshly, the Honorable Supreme Court has set aside the order passed by this Honorable Court and the review applications. Thereafter has been pleased to direct for a fresh hearing, Lord. This is the matter whereby the appellants before your lordships were terminated by the order of the Honorable Single Judge, whereby the educational qualifications capping was there.
Upper educational qualification.
Yes. According to the Honorable Single Judge, that we possess more qualifications. However, in our perusal of the records and everything, and the Honorable Division Bench has held in our favor that there was no capping with respect to the upper qualifications. And there was no specific rule with regard to the bank. On the last occasion, your lordship was pleased to direct my learned friend to bring the rules and everything and the advertisement itself, since it was in Bengali format. Well,
My lordship, I want to indicate one thing that on the previous occasion, your lordships indicated to directed us to file the translated copies. We need one more week to file the translated copies as they are still in preparation. The translated copy are still being prepared, so kindly keeps it after 2 weeks.
So for 2 months, you have not been able to translate how many pages?
My lordship, I have instructions. They are already being prepared. Some of them have been prepared, but we still require one
They
more.
are asking you how many pages? 250 pages or what? 2 months. Orders of 22nd to 24th February. It is 1 month.
today I have served a copy of the SLP, which was preferred actually by the bank only. Before the Supreme Court, they have filed the SLP and there was the scripted
Must
copy.
be there
Yes.
to file.
Today I have served a soft copy to my learned friend.
You are the appellant before the apex court.
Yes, my lord.
Division bench order.
So where is the order of remand?
That on the last occasion I have handed over. Supreme Court order.
What was the order passed by the division bench?
Yes, division bench held in our favor, while stated that there was no rule with regard to the upper qualifications of the
The
bank.
rule was not part of the record.
Yes, yes. And the Honorable Supreme Court has pleased to direct.
The honorable division bench held that no such rule has been placed.
Yes,
Therefore, the
Yes.
ethics court said that the rule be placed and you to be considered. Now
yes,
we remember.
yes. And this is the judgment passed by our High Court only in the appeal. Supreme Court order.
So where is the rule? The rule was there before
It
the
must be with my learned friend, my lord. I have not seen any rule with regard to that, my lord. They have not placed the rule before the Honorable Supreme Court also, before the Honorable Division Bench over here. I only have only one copy of the Honorable Supreme Court's order here. In para 4, it has been specifically stated that for the appellant, bank submits that inadvertently the counsel representing the bank failed to point out that the factual position that there is already a rule, but the same could not be brought to the notice of the court.
Appeals afresh. The item number 4, 5, 7, and 8 for the review and contempt applications has become infructuous.
4, 5, 7, and 8
8.
have become infructuous.
By the order of the Honorable Division Bench, they have only preferred the review application and we have preferred the contempt application. Admittedly, all
Now
these
it is
applications- yes,
infructuous.
infructuous.
The parties are in agreement. Huh?
Nine.
Review the social.
I am for the respondent in the reviewed application and applicant in the contempt applications. Pursuant direct to clarify between the who will be appear in this matter. Applicant.
You were in the writ petition.
No, earlier there was.
Have you seen, did you get any instruction regarding what happened on the last day? And why you are here, sir? This is very unfortunate. Where is she? She was appearing on the last day. Yes.
My lord, she is not available right at this moment. She wrote in this matter.
রিভিউ অ্যাপ্লিকেশনটা আপনাদেরকে দিয়েছি, আমরা WP.ST তে ছিলাম, ওই ক্লারিফিকেশন চেয়েছিল যে WP.ST-র অ্যাডভোকেট আলাদা আর এর আলাদা কেন, সেই ক্লারিফিকেশনটার জন্য আজকে আছে, সেটা আজকে
That's not permissible. So we had asked her to take instructions whether they will authorize him to appear or what they will do. We don't know.
My lord is ready.
You are the respondent in opposite party in contempt. So therefore, you have appeared in the writ court. Therefore, we asked her, every day we have to do the same thing. If she is not here, she should have informed you. This is very unfortunate.
My lord, I am ready for the application.
Oh, you don't think we have understood that by now?
Now, I do not know whether my lord is friend is appealing for the Union of India in this matter. আপনি কি আছেন?
কোর্টে জিজ্ঞাসা ছিল, আবার ইউনিয়ন অফ ইন্ডিয়ার হয়ে রিভিউতে আরেকটা সেট অফ অ্যাডভোকেট কেন, সেই ক্লারিফিকেশনটার জন্য লাস্ট টাইমে। হ্যাঁ, আমি রিভিউটাতে নেই, আমি আছি WP.ST-তে, যেটা কন্টেম্প্ট অ্যাপ্লিকেশন।
Now, my lord, I cannot clarify. Whether my lord, why my lord is has already investigation.
You cannot, we know that. Therefore, she said that I will take instruction that maybe they will ask him. We did not record this in the order. They have not even informed you. Not today. Come find out, not today. Please speak to Miss Ghoshal. You speak to Ms. Ghoshal. You speak to her, she will tell you. She was appearing on the last day, she will tell you.
Number 13.
Where is my lord, 14 people approached before this honorable court, before the learned single judge. Out of 14, 4 were refused the prayer, when not really, and others were granted. These 4 came before your lordship in appeal. Like, the facts of the case is
So 4 persons were denied relief. Out of 13, 9 were allowed the relief.
yes. They will allow 439.
So there were not 13, there were 15 already.
Case relates to, my lord, the measurement of height at the time of selection of the police personnel, my lord, constable. My lord, these 4 persons, they were under height. Just, my lord, their cutoff height is about 160 centimeter. They on 59.40 or 0.20. These are the measurement. Similar situation in the last selection process, they appeared. At that point of time, by the same board, they were declared, my lord, fit, my lord, acceded to the cutoff just few months before. Now the measurement is reducing. That is under challenge because appeal provision is there. Within 48 hours, they have to prefer the appeal before the authority. That has been done by them. Again, the appellate authority measured and said below cutoff. That is under
So
challenge.
there was a remeasurement also.
Yes. But in the government medical hospital, they also measured. Government medical hospital differs from the measurement of the board. That is the case. My only prayer is this, since others were granted relief to the effect for remeasurement, here remeasurement has already been done. A board should be constituted
What is the ground for denying you the relief?
because since the appellate authority remeasured me, there is
In
no,
their cases, they had not availed the appellate.
no, they have been allowed to approach the appellate authority. Only to remeasure by an independent agency, including the medical officers of the government hospital. This is my prayer. That will not, my lord, anyway prejudice anybody.
Oh, it will. It will. The yardstick cannot change. The yardstick has to remain the same.
Yardstick is same.
No, yardstick we are saying physically. That yardstick which has been used, if there is a difference in calibration of maybe 1 centimeter, then it has to apply uniformly to all. For one person, it cannot be rectified. Then it will become whether it will remain.
Yeah, the same board measured me and declared me fit just few months back.
That we have heard. Therefore, we are saying every yardstick has its calibration.
Absolutely.
So, if there is a distinction in calibration, it is to apply uniformly to all. Maybe there was a calibration error in the earlier, or maybe there was a calibration error in this recruitment process.
Maybe.
But whatever it is, it has applied uniformly to all. It is not that for you it has been reset. That's not your case. You are saying in the earlier process, I emerged above 160, here I am falling short of 160. How it can be?
Their measurement, well, somehow they are technically measuring to unfit. That is my case.
No, it's not a case of unfit. It is below 160.
Below 160 because
There you emerged above 160, here you are falling below 160. And the difference is hardly 1 centimeter according to you.
difference is, my lord, only with regard to, my lord, petitioner number 1.06 centimeter.
No, that is below 160.
Below 160.
What is the difference from the earlier measurement?
Earlier measurement 160. Well, this is the comparative chart. Your lordship kindly peruse once. AMANA KHATUN. Height measured first time 159.60. Cutoff is also.
So for SC it is 152.
Yes, for SC or hill areas candidates.
And for EWS also it is OBC standard. And what is the normal standard? 160.
160 is the normal.
So only relaxation is for SC and hill areas or tribals maybe.
Right. Yeah, now, AMANA KHATUN Well, 160 is the standard. 159.6.
So what will happen if this time you are assessed at 159.40? Then what you will do? Can we say that they are barred from measuring less than 160? Or rely on that report in the earlier process?
That Malad made the lordship kindly see. Previous selection, it was on 160.4.
Therefore, we are asking you, can we say that you rely on the measurement in the earlier process? We cannot say that. That is over.
Malad, the
So today, can we say you cannot measure them less than 160?
proper measurement is required. It can be 160 or below 160.
So what will happen? Therefore, we are saying if this time they come to 159.40.
I will be out.
So it is just that you should have your second measurement, third measurement, not second.
Because medical certificate, the lordship last column, 160.440. This is the medical certificate issued by the government hospital. This said. Therefore, your lordship in another matter in PW2 case, where your lordship hold the government hospital certificate cannot be ignored.
No, we held a statutory certificate cannot be ignored. The statutory certificate is, we did not hold.
PWD category.
Yes, we did not hold government certificate cannot be. We said that the government's measurement cannot be relied upon. Only the statutory certificate will prevail. Because at the time of giving the fitness certificate, they assess something else. We said that government certificate is not reliable. The statutory one will prevail.
Yeah, statutory authority measure twice different.
There is no
measurement.
statutory authority here. There is only one statutory rule. That rule contemplates measurement in a particular way, and that measurement is the only measurement which can be relied upon. No other measurement can be relied upon. Whether done by a medical professional, whether done by anyone else. Otherwise, the recruitment process will never conclude. Everyone will come with a separate measurement and say, look, I have got this from this hospital.
Same body, same authority, same measurement. They differ.
Last time he was assessed. Maybe last time was difficult, very difficult.
Authorities discretion they exercise. Lordship guidance is not the part of the record.
An issue of distributed force, which cannot be by the where is the advertisement?
Advertising.
Have you filed certified copy of the order?
The lordship granted leave without certified copy.
So limitation will be counted till today.
The lordship granted leave to
That is all right, but limitation will be counted till today. Then what is the date of the single judge order?
10th of this month.
10th of this
February.
month.
February. 8th of February. হ্যাঁ ঠিক আছে।
Then 7 days.
7 days delay. If there be merit, it can be condoned by your lordship or on application.
Board is also represented. Who is for the state and who is for the board?
My lord, I am appearing on behalf of Mr. Kolan Bandyopadhyay. He is not available
You are
today.
for the board or the state? Board. And who is for the state? State is also a party.
Board and state is same mind.
But he is not available. Keep it on Monday.
Meantime, you file a short application. You learn it application.
The certified.
This give to the judge. He has to quote from that paragraph 4.
Now 14.
And 14 both are same matters.
The 14 is their appeal, my lord. Against the 11 employees who had been allowed against the 11 cadet.
The issue
Common order. In 14, just pass.
Then 15. 15, I think. Shortfall of service of 12 days.
12 days.
Only 12. Result order will at page 78. Kindly have a look. And the original applications order is at page 76. And your lordship's judgment was assailed before the Honorable Supreme Court. But I have also annexed that. At page 81. And the judgment of and the order of the Supreme Court has page 89.
Yes, who is appearing? Who is appearing for the state?
On the last day, somebody appeared.
Somebody has filed a report also. Who appeared? Mr. Ansar Mandal. Hmm? What are you saying? He's an AGP. His name is appearing. He has submitted this report.
What upsets? Barodin.
This report was sent by the authorities to one Mr. Ashish Datta, learned state advocate, Group B. This report was also sent to him.
Please. Well, kindly direct Mr. Mukherjee to appear because it will be.
Where is he? When he is appearing, why a different council should appear? This is, huh?
It's not to speak.
What is the matter? Tell me.
But Mr. Mondol does not appear in.
Answer appear corner.
Then who appeared? Who filed this? This is addressed to him. Last day also his appearance has been filed. So if we ask you to appear, then report is already there. What is to be done?
shortfall of service এটা আপনি এটা বলছেন সে বুঝেছি আপনি
There's 12 days shortfall, 12 days.
বলে দিচ্ছি
He has completed 9 years, 11 months, 17 days.
irrigation water wells
So 6 months they can consider.
Give him a copy of the report.
but report I don't have only one copy has been handed over to the honorable court I don't have the copy
What is the practice? Normally report copy is served on.
no but the copy is to be handed over to the honorable judge
No. Normally it is to be supplied to her.
if the honorable court says then only the report we get the report otherwise the reason order is same the reason order is there 12 days short and the court has also recorded the tribunal in the earlier order kindly have a look at the tribunal's order page 76
What does it say?
12 days short form page 76 court line from top.
Gopal Chakraborty.
Tribunal directed the respondents to consider the response considered pass the result order page 78 page 80 is the operating fund
You said that additional chief secretary is not the competent authority.
On if this it will have to be disposed of in the same terms. Just have a look.
I am appearing for the petitioner. My lord, there was a direction to file affidavit. We have received affidavit. We have drafted the reply, but my lord, it could not be affirmed. My lord, my lord, require 2 days time, my lord.
My lord, Advocate Bikash Ranjan Yogi is appearing in the matter, my lord. He is out of station due to his wife's illness. I am praying for 1 week's time in the matter, your lordship.
Have you served copies? Copies have been served. The learned AGP.
Appealing for the state, my lord. Last time, the lordship please to direct me, my lord, to file affidavit, my lord. We have affirmed the affidavit, my lord. One first day, my lord. Lordship, at the time of affirming, my lord, the Home Secretary has been transferred, my lord. Home Secretary has been transferred at the time of affirming. I have written at erstwhile, my lord. Home Secretary has been transferred during affirming, my lord. That's why I have written that erstwhile Home Secretary, my lord. That point I must say, my lord. Kindly consider this point, my lord. Yesterday, my lord, affirmed. And sir, R2, my lord, the relevant memo, my lord.
The erstwhile Home Secretary is a party.
This one, my lord.
Erstwhile Home Secretary. To understand the procedure at all, or
Yes,
you
sir,
just
my lord.
do something like
Allow
that.
me to file afresh, my lord.
How can you do this?
Yesterday has been affirmed, my lord.
So therefore you will do anything.
I'm paying apology, my lord. Allow me to file
What is this?
afresh, my lord.
There's to be some limit to the way you.
Kindly allow me.
Some officer has signed the paper, he has left it with you. You will affirm it by saying he is the erstwhile officer
Yes,
after he has demitted office,
kindly pardon me, my lord.
and you will place it on record in the court.
That's a very, very
What is
beginning
this?
I have said, my lord.
Therefore, everything is okay.
Kindly allow me to file the new affidavit, my lord.
He has ceased to be Home Secretary with effect from which date?
Yesterday, my lord. Yesterday, my lord. Sunday night.
So therefore, on Monday, how he can swear an affidavit?
I have said, my lord, that they have read.
He has sworn an affidavit saying that I am the erstwhile Home Secretary. Wonderful.
Lordship, Sanghamitra Ghosh, my lord.
Take it back.
Lordship, will allow me 1 week time. Maybe.
Give it back to him. The learned state.
Grateful. Sabay.
19.
For the petitioner, Lord. Last occasion, Lordship was pleased to direct the Lord AGP to submit a compilation, last occasion. To submit compilation. My Lord, let a copy be handed over to me. Your Lordship was pleased to direct to give me a copy. His duty to search out all the notifications and statutes. It's a court's order.
What is regarding the volunteers?
My Lord, Civil Defense Disastrous Management Force.
Take a copy from him.
My Lord. And my Lord, I'm praying I shall come back on 30th, my Lord. Before that, my Lord, the Ramzan will be completed and the Eid will be
30th.
30th. my Lord.
None appears for the writ petitioner. Understand.
Your Lordship, praying for a short Passover.
25.
25, yes, Your Lordship.
We have passed the order. You are not, nobody was appearing. Oh, 24. You are for?
Petitioner.
Not today. 26.
I am appearing on the other. Supplementary. Absence of myeloid thought are that. Any copy paste? Price this quote myeloid.
The last location, my lord, remember that there is a specific provision in the advertisement. The reserved category seat ought to convert in the unreserved category. And in this regard, my lord, they filed the affidavit in opposition. Because of that, my lord, is well aware of the fact that, my lord, under the Disability Act, my lord, kindly take their opposition filed by them. Page number 17. This is a vacancy reporting, my lord, pro forma for page number 17 of their opposition filed by one Sri Nishant Mukherjee.
Supplementary opposition or main opposition?
Main opposition, mother. Filed on 14th August 2025. Affirmed on 14th August 2025. This is, my lord, regarding pro forma for reporting vacancies. My lord, got it?
Yes.
Heading of this page number annexure R2, page number, my lord, 16. Pro forma for reporting vacancies for selection stroke recruitment to filled by the West Bengal Health Recruitment Board. My lord, kindly take very next page, page number 17, and entry 14. Entry 14. Page number 17, entry 14. If the vacancy stroke vacancies reserved for physically handicapped candidate will be treated as unreserved in case of non-ability of qualified, right? Yes or no? Yes. So, my lord, the pro forma vacancy says, which is a government interdepartmental communication says, if a seat is reserved for the physically handicapped candidate, if the seat is unavailable, then that ought to convert in the unreserved category. Now, my lord, in the advertisement itself, it is mentioned. Kindly turn page number 40. The advertisement starts from page number 39. In the writ petition, my lord. Sorry, my lord, pardon me. Writ petition, my lord. And petition. Page number 40. Note. In the line of that same pro forma, my lord, in the advertisement, they mentioned that go to the middle after it. The vacancy stroke vacancy reserved for physically handicapped candidate will be treated as unreserved in case of non-availability of qualified. Now, kindly turn thereafter page number 112. In the year 2023, 31st July 2023, West Bengal Health Recruitment Board published a notice. May I read one? Notice. Notice the overall performance of all eligible candidates my lord, whosoever the eligible candidate, they are on of including those who are selected in the panel and category-wise panelists for the post of staff nurse, grade 2 under Health and Family Welfare Department. Are hereby published. Now, my lord, in GNM female category, my lord, that is our category, my lord. Kindly see whether the last column, the PWD. My lord, PWDC, my lord. There are 8 notified vacancy, 89 notified vacancy. Now, my lord, very next one, my lord, number of candidates in the panel list. How many? Only 6. So that means, my lord, 83 candidates, my lord, that vacancy is available. So that 83 vacancies, my lord, ought to convert in unreserved category, my lord. According to the notification, according to the advertisement, as well as the pro forma. Very right. Now, my lord, kindly take thereafter the supplementary review, which I filed today.
What is the last vacancy position at the time of creation of the panel?
Pardon me, my lord.
As per the advertisement, the anticipated vacancy as on the date of creation of panel was required to be the basis. What is the last vacancy position on the date of creation of the panel?
Kindly turn my page number 100. Kindly turn page number 100, my lord. As per their record, the vacancy position, my lord, total 3,561. Out of that, my lord, unreserved is 1,355. Out of that 1,355, number of candidates in the panel is 1,355 in the case of unreserved. In the case of SC, out of 1,096,000 on the selected.
No,
But
the
in the case of
modified,
PWD,
the vacancy position is at 113, not 112.
yes, my lord, that is as per the notice, my lord. Yes, my lord, that is as per the notification. But after the panel, my lord, what is the vacancy remaining? My lord, that's my contention, my lord. That is also reflected in the same line. Because of that, my lord, it is after the vacancy, what is the exact number of vacancies?
The advertisement contemplates the vacancy, including the anticipated vacancies at the time of creation of the panel.
Yes.
So the vacancies, including anticipated vacancies at the time of creation of the panel, is at 113. You please read what is written above the table. You will realize what we are observing.
I follow, my lord. My lord, initially, the vacancy was, my lord, page number 111. This is my lord, page number 111. That is
Kindly
inside.
read, sir. Kindly read what is written above the table at page 113. We need not go through all the earlier lists.
Yes, ma'am. I follow.
Whereas in terms of the aforesaid clause, it is notified that the anticipated vacancies as mentioned in the original advertisement is hereby modified in the following manner. So this is the basis of the recruitment. This is the basis of creation selection. The earlier which you have shown, that list is a panel. It is not a select list. It is only a panel. It includes those who will be selected or those who have been selected. But the selection is based on this vacancy position at 113.
Yes, ma'am. But my lord, ultimately,
And at this page, the number of vacancies under PWD is only 2 for female. You see post basic BSc, that is for female. There is only 2. Total 50, 48 male, 2 female.
pardon me, there is no such, my lord, all are here.
PWD 42, basic BSc, post basic BSc 2. This is the vacancy. Total 44. New vacancy 6. So there were 2 vacancies existing at the time of advertisement. No other vacancy arose under the PWD female. Therefore, the modified vacancy remained at 2. This post basic BSc is the column for females.
My lord, pardon me, my lord. Kindly, my lord, take my submission. My lord, we are not staff nurse grade 2, my lord. This is, we are for GNM female, my lord. That is, my lord. My lord, kindly pardon me, my lord. That is, my lord, staff nurse grade 2. We are not contesting for that. We are
Oh.
contesting for GNM female.
Which is at 112.
One. Pardon me.
Very well.
We are not contesting for that, my lord. That's why, my lord,
You are not concerned with
no,
this
no, no,
stuff.
no, no, my lord. We are concerned, my lord, about GNM female, but because all are female, my lord. Kindly see the overall performance which is annexed with my writ petition itself, my lord. We are contesting for GNM female, my lord. In GNM female, it is, my lord, published in the 2023. What is the vacancy actual last vacancies, and, my lord, the number of candidates in the panel list in the respective category. That is, my lord, I just, my lord,
So they have appointed till which position?
Till, my lord, kindly thereafter take, my lord, my supplementary. During the pendency of this particular case, my lord, they publish the second panel, which is annexed with the supplementary affidavit, my lord. That is second panel. That is, my lord, page number 5 of the supplementary affidavit today, which I filed, my lord. The last candidate. What is, my lord? Page number 5. Kindly see, my lord, the Suchisri Chattopadhyay, the last candidate in the second panel. My lord. The first panel published. Thereafter, in the month of March 2024, the West Bengal Health Recruitment Board, they published this second panel in unreserved category. The last candidate, my lord, got it, Suchisri Chattopadhyay. What is
Page 5.
yes, my lord, page 5. Page 5 of the supplementary affidavit. Serial number 30. The first annexure P4. And I awarded in para 5 mark.
Supplementary affidavit in opposition.
No, mark. Supplementary affidavit.
Oh.
Supplementary affidavit on behalf of the petitioner, which is filed today, my lord, affirmed on 17 March 2026. Yeah,
Paragraph 6.
paragraph 5 and 6.
Yes.
And my lord, kindly turn page number 5, my lord. I can first, my lord. This second panel.
This is the second panel.
Yes. During the pendency of
Which serial? Up to which serial they have appointed?
serial number 30. Serial number 30. They, because of their chronologically, they just put it the chronologically, but they not mentioned their overall performance merit position. I will show it, my lord, which is also annexed in this supplement.
1404.
Yes, my lord. 1404.
And you are at which serial?
My lord, our serial number, I made a tabular chart for the convenience of this court. My lord, kindly turn page number 12. I made a tabular chart. Got it. Made by the petitioner. It will be helpful for the court. The serial number mentioned in the first column in overall performance series, merit, that is merit position. Petitioner number 1 in overall performance serial number 1496. Petitioner number 2 1462. Similarly, petitioner number 3 1499. Similarly, petitioner number 4 1406 is the first candidate amongst this petitioner. So if that seat is converted, he will be the first candidate. She will be the first candidate. Pardon me. She will be the first candidate.
So these petitioners are of which category?
All are unreserved category. Well, category is also mentioned.
And this person at serial 30 is of which category?
She is also unreserved category because second panel all 30 candidates, they all are unreserved category. Well, kindly turn page number 13. I also mentioned the serial number 30's merit position, her marks as well as her category.
So any vacancy will come only after this person.
Yes, yes.
1404.
1404.
After 1404.
1404 plus 83. Amongst them, my lord, there are certain candidates. For that reason, my lord, I made a tabular chart, which is also annexed with my writ petition, page number, sorry, my lord, supplementary.
So there are, according to you, there are 6 writ petitioners.
7.
7.
All will come into the zone of consideration.
How?
If the 83 seats, the vacant 83 seats is converted to the unreserved category as per in terms of the advertisement or in terms of the pro forma. Because of that, Disability Act says, well, after certain period, the candidate, the department may convert the seat if the reserve physically handicapped candidate is not available.
So it will go to which category then?
Unreserved category, Malad.
It will not.
Malad, it is mentioned, Malad, specifically. Malad, I made a tabular.
It will not be reserved for PWD, but it will be reserved for the category OBC, SC, ST unreserved. It will not go to unreserved. Never. Cannot. Cannot.
Only reserved category.
Only reserved category. See, there are PWD candidates in general category. There are PWD candidates in OBC category. There are PWD candidates in SC category. There are PWD candidates in ST category.
I follow my lord, go down for that.
So therefore, they will not go to unreserved.
My lord, in
They
a-
will go in the respective category as per
I
roster.
follow, that will follow the 100-point roster.
Correct.
My lord, and my lord, particularly, I want that, my lord, they not yet.
So therefore, you cannot say that all of them will be made available to you.
I am not saying
You
that.
don't know
But
which one is falling in SC, which one is falling in ST, which one is falling in OBC.
I am go down for that, my lord. For that reason, my lord, I made another tabular chart, which is also NSU
Yes.
supplementary.
Yes.
That they've made a huge labor for that, my lord. My lord, kindly see.
No, that is good to see. It is good to see. We also
My lord, kindly
appreciate if you yes.
petitioner made a tabular chart,
Page
number 14.
Page
14 of the supplementary
14.
14 of the supplementary affidavit which I handed over today, madam.
Yes.
Madam. So last selected candidate, according to them second panel, last selected candidate was 53. Now, madam, 1405 onwards, their vacancy, madam, will be converted. So I made a
How do you know? How do you know there? How many vacancies are there
because
against OBC, SC, and ST in the PWD category? How do you know?
madam,
What is the basis?
madam, kindly page number 112. 112 is the final merit position, final vacancy position.
112.
Yes, madam. There are specifically mentioned 112, madam.
That's all right. They are saying 89, 90, whatever. Which will fall in which you don't know.
Madam,
Which will fall in UR, which will fall in OBC, which will fall in SC, which will fall in ST. You don't know.
madam, in
You,
this,
there is no way for you to know.
madam, then madam, the department only says so. The whether my tabular chart is right or wrong.
Why? You have to convince us first that there is some basis. You can't just throw anything to the court and ask them to deny it. You have to make out your case, then only we will ask them. Unless we are convinced, why we should ask them?
Madam, 1404 is the last selected candidate. Whether they convert a single seat, madam, according to us, madam, they not convert a single seat.
What is their stand in the opposition?
Maybe, madam, they are.
The panel expired on 31st July 2024.
24.
24.
20?
24.
During the pendency of this case, my lord, the panel valid, but we filed the original application immediately within the validity period of the.
Very well. Maybe. So what is our stand in the opposition? What is your stand?
These 34 subsection 2
Huh?
of the, we have followed the section 34 subsection 2 of the Disability Act 2016.
Yes. Other one, red one. That is the new one. Yes, like that one. This old one, 95. Oh. 34 2.
34 2. Popular reservation, 4% reservation. Then subsequent. Yeah. But the people are this is all for areas that are such subsidy. Yeah. The post of began the vacancy by appointment after the conference provided the elections the vacancy interchange among the 5 categories to declare appropriate. When a person is disputable candidate on the affordable, we have carried forward to the next vacancy. Present.
What is the date of the advertisement?
Second February 2020, page number 45.
2020.
2, page number 45, according to the record. And the second panel published in the month of March 2020.
So you are relying upon the advertisement only.
May I appraise this code in two positions, Malar? The section as well as the pro forma, because pro forma is very clear. Kindly turn page number 17 of the affidavit of opposition filed by them. Entry number 14. It is converted, department mentioned it is converted in the unreserved category. Kindly see, Malar, entry 14, page number 17. If the vacancy reserved for physically handicapped candidate will be treated as unreserved. Unreserved in case of non-availability of the qualified. Yes. So, according to the section 34, that is due to non-availability of succeeding year, that converting the unreserved category. That is the
Cannot be. Cannot be. That is a presumption you are raising by reading that provision. Cannot be.
Not presumption.
There is nothing to say that it was ever interchanged for the other category. There is nothing to show. It can be de-reserved only after the interchange exercise is taken.
Yes.
There is nothing to show that an interchange exercise has been undertaken.
Kindly turn page number 17
Of?
17 of the affidavit in opposition and para 8 because of they admit it and thereafter they said we have nothing to do. Kindly see, I just read the two paragraphs of this affidavit, affidavit in opposition filed by one Nishan Mukherjee on 14th August 2020. Page number 13, there is a note, departmental note.
This you are not concerned with. This is much after your advertisement.
Kindly turn page.
This is much after your advertisement.
Yes.
This is not relating to your advertisement. Yes.
Mention in para 7 and 8
Yes.
because they annexed it. For the reason, the departmental communication is also annexed. Kindly see,
Sir, this pro forma is for reporting vacancies as on 21/9/22. That's much after your vacancy was advertised in February 22. 7 months after that.
Yes. But
Yes, sir.
notification, the departmental communication is mentioned in page number 30.
Hmm?
No,
Page?
30 of this particular proposition. Right, with note, can you take the note? Notice for modification of vacancies for both the advertisement, that is staff nurse grade 2, basic and post basic nursing. GNM is also mentioned for recruitment to the post of staff nurse grade 2 are already published in the official website WP.ST. The mail has been sent to WPM for modification of such vacancies. The application software. It may be proposed that the extract of the file may be downloaded and attached to the file number such as that. Subsequently, the file may be returned to the department. Health and Family Welfare, subject to approval of higher authority. That is 5th August 2023. May please note thereafter.
That is 1 year, that is 1 year after page 16. That is not in correlation to page 16. Page 16 is of September 22. This is of August 23.
Mentioned matter.
There is no way you can relate.
7 onward matter, para 7 and 8. Specifically, they say about perform vacancies regarding and page 40 of the advertisement matter. Kindly see with the above portion. The anticipated vacancy may change before the date of publication merit. In case of any change in the vacancy, subsequent. So subsequent notification modified vacancy matter 21st July 2023. That is page number 112. That usually current validity is 1 year, but here was they published the second panel in the year 2024. The panel was alive up to 2024. The original application filed in the year 2023. And they mentioned it, they want to convert it, but they have no role to play. That they are according to their evidence. I just read one or two paragraphs of their evidence. They was received according to their affidavit 21st September 2022, not after advertisement, prior advertisement, para 8 of the particular manner affidavit. Can you see the date? Performer, when they received that performer vacancy position, para 8 of their affidavit. The affidavit opposition. Specifically mentioned, specifically about. Second December 2022, but pro forma vacancies received on 21st September 2020. It is mentioned in para 8. Paragraph 17.
You have filed reply to the opposition, both oppositions. Have you filed a reply to the oppositions? No, you have filed supplementary affidavit. You have not filed reply.
Court only recommended it, whether post to be converted or not, that depends upon the department. We have said to in page 3, the post development being a recommended authority has no role in converting unfit vacancies into unreserved.
So who is appearing for the department? You are appearing for the department. Huh?
Board.
You are for the board. Anyway, where is your reply?
My reply filed, already filed, my lord. That is,
You have not filed any reply. We are unable to find your reply. Just see if it is there. See, we'll come back after post recess. There are one or two matters picked. So that will take up. Yes. We'll come by then, therefore we'll see. It will take some time.
because it is fixed at 3.
Before 3, we will complete this.
Sign matter item number 1.
On behalf of either of the parties, we adjourn.
Item number 2.
Your Lordship, I appear on behalf of the appellant.
Who's for the state? Argument is over. Your
No,
argument.
Lordship, what it was heard in part, Lordship. Lordship, as per the last order, there was a direction to
No, the
serve.
learned Advocate General said he would be filing a notes. Where is there's nobody to represent the state today.
Yes, Lordship.
There is none to represent the state.
Item number 3.
This is my appeal, my lord. My order passed in a section 9, my lord, of the Arbitration Constitution Act. My lord.
Only one thing I wish to draw your lordship's attention to, well, this is an appeal from an ad interim order. Well, since then the affidavits have been completed, the matter is ready for final hearing. And well, in the final hearing also, well, we have finished our arguments. That is recorded in orders of court.
Final hearing record.
Final hearing, my lord, has commenced.
Oh,
Our arguments, my lord, has already also been concluded.
My lord, may I, my lord? My lord, that would have been a correct proposition, my lord. I always agree to that, my lord. But here, my lord, there is a question of jurisdiction in respect to the order passed. Because, my lord, what has happened, my lord? When an order has been passed, other than being unreasoned completely, my lord, it is in nature of, my lord, a security, a double security on the basis of, my lord, submissions made by the third party in a section 9 petition. In a section 9, my lord, the adjudication has been vis-a-vis the rights between my client and a third party, finding that I am at a wrong. My lord, orders have been passed in a section 9 initiated by my learned friend's client. Therefore, my lord, the question of jurisdictional issue can be taken, my lord, in spite of that. That is my submission. My lord, will kindly see the order itself, my lord, even without going into the merits of the case. Your lordship sees the order, your lordship will find it that way. If your lordship takes up the memorandum, is the lordship with the memorandum? Memorandum. But here, my lord, it is a case, my lord, where, my lord, the petitioners are saying that they have a claim in respect of a loan, my lord, against my client. So they file a section 9. In the first section 9, my lord, they secure an order of sale of certain shares. Now, those shares could not be sold because of, my lord, the defenses taken by the stockbroker. But the stockbroker comes in and says that I want a vacating of that order. Then, my lord, what happens? The learned single judge, my lord, goes into, my lord, my whatever steps I have taken with the stockbroker, whether the stockbroker was acting correctly under the SEBI rules or not, and then finding that I have not acted in terms of the SEBI rules because I have violated my own trust deed. That is why, my lord, an order is passed. My trust deed is not within the domain of this section 9.
no, the issue is whether the sales should have, shares should have been sold or not.
That was the first. Now, since I have not sold the shares or I have not been able to sell the shares, another order is passed on some other shares.
That you don't sell it.
No, this is on some other shares.
That you don't sell it.
Don't sell that.
Because it's kind of a security intended for the loan that they are trying to realize.
But the injunction is there. May I just say, point out, it's a security.
That's a cursory glance from
Yes,
that is what
that part of the order, with humility, I say, that is
Only on submission, there is no reason. The reasoning is in the light of this.
That's all right, but
Other
when
than
the
that,
final argument is going on, what is to be done now?
I mean, these shares are being, these are being held on as a secondary.
The date of the order.
The order has travelled. I'll point out
December
why,
2024.
I'll point out. No one was ready to take it. Every judge was releasing it. Because one of the trustees is a lawyer known in this court. So ultimately, in spite of our making the specific,
Whatever may be, but now more than a year it has been pending and it's on the, you're already in the midst of final argument. Then what is the point in looking at this matter now? It will be concluded.
But the only thing which I'm just submitting, I'm only on the proprietary whether an order without reason can stand or not.
Once the final order is passed, will this order remain?
Final order kindly appreciate, which again, kindly does not take me amiss. Final order in a section 9 is an interim order.
Obviously, yes, but the proceeding is finally disposed of. So this ad interim order will not sustain.
That's a question which is being heard because the arbitral tribunal was also fixed.
Correct. So those are issues yet to be considered. We will not.
Different point, Today, it's not a question of. I am only on the point whether the court can adjudicate on an issue which is not subject matter of the section 9 while passing an interim order.
To what
Because if this case,
we appreciate that, but what we are asking you is to what avail when the issue is now for final hearing, it is going on already.
Observations are there already.
This is subject to final outcome of that proceeding. This will not sustain after the final disposal of.
Again, absolutely, but the points which has been on the basis of which this order has been passed, I am saying they couldn't have been agitated. It's not on the order itself, per se the basis. Going into disputes which are not within the subject matter of the arbitration, a section 9 court cannot look into it. That is the only basis,
But that will be whatever that is decided in the section 9 now, that will be subject to scrutiny in an appropriate proceeding.
May I interrupt my learned friend? Ultimately, section 9 is for interim measures.
Correct.
Now, the interim measure directed here is an interim measure of security in respect of assets which my learned friend owns, so that my loan is protected. My learned friend wants to argue the point of jurisdiction, all is well and good. But I don't understand how section 9 jurisdiction can be questioned when all that the court has directed is security for the loan.
I could have understood it.
And as going through a few pages, what I could gather is that in substance, the court found it fit that you don't sell shares.
But on what?
Because there is a recovery of a particular amount of loan which they are trying to make.
That order has already been passed.
Yes.
A separate tranche, which was agreed upon. Rather, it was not agreed, but whatever it is, these are two.
So, what is the part of the order which you are so aggrieved by today?
But just give you 1 minute. In the first order, they get a security of IPCL shares. Kindly keeps this in note. The name of the share, IPCL. And then there is an order passed that you sell the shares and put it or sell the shares subject to further orders. That is pending. Now, when we tried to sell it, the broker or the demat account with whom I have the demat account, there is certain objections. That is an objection which was before this court in a separate suit also. And with regard to which another suit is pending in Alipur. Now the single judge finds in this second application which they make, that application they are saying that since you did not sell it, the injunction is there as a security. Since you did not sell it, we should get another injunction on Hiranmoy shares now. Same value. So double security, and order is passed only on the basis that I could not sell it. And why I could not sell it? Because the trust deed, this is my trust deed, it has got nothing to do with them, proposes us to act in one way. We have failed to act in that way. Therefore, the broker was right. Therefore, I'm passing an order. Just simple. Kindly see the last page of the order.
May I, my lord, ask myself one question? It may be a suggestion. Your lordship will consider it. My lord, when I want, my lord, there's a direction to sell the IPCL shares and to keep the proceeds of the sale, my lord, as security for my loan. Now, my lord, when I want to sell the IPCL shares, my learned friends are vehemently objecting to it. My lord, let an officer be appointed by your lordships, my lord, because the other special officer could not sell it. Let the shares be sold, my lord, I shall not press for this.
Well, this is quite
My lord, he will
unfortunate.
not let me
I've
sell
never
the
opposed.
ICPCL shares.
I've
He will
never
not
opposed,
let
my
me, my lord.
lord. What I have opposed, my lord, this is very unfair. I will show their application.
My lord.
They have said that you appoint some other DP. That is what I oppose. You cannot.
No, my lord, let
My
me,
DP
my
cannot
lord,
change.
cut through all
And a
that.
single bench.
If my
has
learned
refused
friend,
that order.
if my learned friend, my lord,
Unfortunate.
allows your lordships to appoint a special officer for the sale of the IPCL shares, my lord, I shall, my lord, proceed with that sale.
But that
Once
order-
the shares are sold, I will, my lord, even immediately give up this field.
And that order has already been refused. He is not preferable from there.
That is what is, kindly see,
Yes,
my
yes,
lord,
sir.
my lord, today I will not allow you to
How-
sell the
my lord, the
IPCL shares.
receiver is already
I will not
appointed.
allow you to, my lord, have injunction on these shares.
My lord, receiver is already appointed.
But the receiver is not being allowed to sell, my
When
lord.
is the next date fixed for final argument?
My lord,
My lord, may I suggest
March, 25th March.
your lordship,
25th March. Come on.
23rd
your
March,
lordship only
25th.
my lord, then send, my lord, there are
Finished their arguments in November 2025.
remarks. There are remarks which has been made, my lord, against the trustees of my company, of the trust.
Ad interim in nature.
My lord, only this part, my lord.
This is not a final order.
Oh, my lord, kindly appreciate, my lord.
You can raise the issue
My lord,
once the
that's
final
what I-
order.
Kindly, my lord, keeps this issue to be decided by the single bench also.
My lord, who has said that, my
No,
lord,
no,
this
no.
cannot be re-agitated?
My lord, I have taken this
Who
point.
is limiting anything to be raised before the?
Today, my lord, I have preferred an appeal from that.
Yes.
The lordship is not.
No, we can dispose it off by saying all issues are open. You will agitate
My lord,
whatever
these
you.
remarks will not be taken effect. Why I am saying, my lord? My lord, please appreciate.
At the stage of final adjudication,
My lord, kindly look.
what is the relevance of these remarks which have stayed on the record for 1.5 years now?
Point out why, my lord. Kindly, just gives you 1 minute. My lord, on the same issue, my lord, there are suits pending.
So
So this finding, my lord, will have a bearing on a law.
please see, we want you to take a stand in respect of this issue. We don't want to go into this issue and direct you to do something. Since the 25th is fixed in the matter, you are arguing it, you will raise all the issues.
23rd and 25th,
My
2
lord, I
days
will-
are fixed.
I will raise
Two
the
dates
issue.
are fixed. Then why should we? This is unnecessary.
My lord, this
Today is already 17th.
But I'm
That
only
means
want-
next week,
and I'm only wanting some
Monday.
protection.
Monday,
And I'm only wanting some
till
protection.
Monday.
No, no, my lord.
What is
I'm
it?
not, my lord. Kindly appreciate what I'm wanting, my lord. And kindly give you 1 minute. Let me try and explain, and then you're also will. My lord, there are, my lord.
What remark? Show from the order.
Definitely.
Yes.
But kindly takes the order. But kindly sees paragraph 25, 26, 27. This is most important. This issue, whether, my lord, the broker, the DP account holder, should sell or not, is in a separate suit before this court.
Again, you see once.
He's not a party. I know that. But that is what I'm saying.
We are not on the merits. You said
But
there
we
are
are on the merits.
some remarks that you want
Yes,
to be.
my lord, kindly sees.
Where is that remark?
This court finds.
Yes.
Since the year 2017, this court directed to sale of 32.
Those are findings. That's not a remark.
My lord, that is what I'm saying. My lord, this
This
finding
is not a remark. You said there is some remark.
of another suit, my lord.
So what is the,
But it is not a dispute with my learned friend.
sir, when it is being adjudicated finally in the coming week, why should we go into it? That we are asking you.
I'm only saying
What
this
is going to
because-
happen between today and 25th,
because my lord,
which you apprehend that an order is required to be passed?
can put it to that extent.
Yes.
These observations will not have any final effect on any orders.
How can it? It's
Because
an
my-
ad interim nature
Kindly
finding.
see 26 months.
Mean that your lordships are interfering with the order.
Kindly see 26 months. The documents provided by the respondents to the depository participants clearly reveals that the said document is not in conformity of SEBI circular. This is not a dispute with them. It's pending in an issue in a suit against the broker.
And my lord, when I
Today,
want the
I don't
broker to
find
be
it, my
replaced, my learned friend is opposing it.
My lord, today,
Just read the next paragraph.
yes, my lord.
Findings are
Not-
prima facie. These findings are prima facie. They are no conclusive finding.
Say this
Please read the next paragraph.
My lord, considering this above, court finds the petition is made of prima facie.
Prima facie case. So this is not
Yes,
a,
my
this is subject to the final order.
And only says, my lord, I'm only on this, my lord. This is not the subject matter of section 9. That is what I'm on.
We are not on that. We are on
But my opinion
now.
only on that.
Now it is at the verge of final hearing. Where is the question of going into it now? If it could remain for more than 1 year, then what is going to happen in 4 or 5 days? That we are asking.
But again, Malad, I'm only on that if this order, Malad, if your lordship just dismisses my appeal, Malad, this will have some effect because it will become.
How it will have any effect? How it will have any effect? That's what we are asking you.
Then, Malad, kindly then specifies this point to be kept on specifically.
We are saying everything will be left open. Everything. It's an ad interim order. There is no final adjudication. The matter is now going through a final hearing. The parties are at liberty to raise all issues. What else can be said? At this stage, what else can we say? At this stage, what else?
And then it says that these are tentative and to be about Malad, at least that much, Malad, so that I can show it to other courts, Malad. That this is tentative. But I'm only worried about that.
Can anyone say it is subject to final outcome? Can anyone say? Can they say it is not subject to final outcome?
Malad, only thing is I'll point out, Malad, we go on a regular basis, Malad, to courts, Malad, which are inferior to your lordship's courts. Now, this is a practical explanation which I'm giving your lordship, Malad. When these things happen, Malad, it is very much, Malad, taken by.
Now it is next week. We will just say that whatever findings are there, we are not going into it because it is at the stage of final hearing. Parties are already arguing it, and all issues are open to be. That's all. Yes.
That may I have your lordship's leave, my.
Please, yes. The final dispute. Now nothing will remain after this order. In this case, nothing will remain.
No. But this heard of the appeal is also heard of.
Let us 16 December. You said 9 December. Oh, 9 December. Order is of 16 December or 9 December? 16 December.
2024.
24.
24.
Not 9 December, 16 December. Ask him to correct.
So,
order is not 9/12, it's 16/12. Yes, thank you.
This one.
This is which serial? Which serial? 97. 97.
Yes.
We are just reading the operative. You are appearing. We are reading the operative portion. In view of consideration as above, we find no justification for the management to resist consideration of removing the pay anomaly and are of the view that such anomalous situation gives rise to an enforceable claim in favor of the writ petitioners and a corresponding obligation on the respondent authorities to take remedial action for removing the anomaly which they have failed to do despite repeated assurance for nearly 5 years. In view of such failure by the authorities to remedy the situation, we find a situation existed for issuance of a direction by the learned single judge upon the respondent authorities to take steps for removing the anomaly. The direction of the learned single judge is founded on the above noted resolutions for removal of anomaly. The learned single judge, while issuing the direction, has not directed in specific terms as to what basic pay scale the petitioners were required to be placed in. He has left it to the discretion of the authorities to take a decision within 14 days from the date of communication of the order of the writ court. He has allowed consequential benefit, including arrears, as a result of such decision to be taken to be paid starting from before 23rd October 2019, as if it was even if it was to be paid in installments. The appellants failed to make out a case for interference with the directions of the learned single judge. Considering the pendency of the present appeal, we consider it necessary to modify only the time for consideration in compliance with the directions to be within 14 days from communication of this order. The appeal is accordingly disposed of.
Has given 14 days.
14 days. It was 14 days from the court's order. Now it is from the 14 days from our.
Number 101.
One. Please approve. We find no merit in the review application. The same is dismissed.
Item number 12.
My appeal, this is an appeal against an application allowing an application under order 21/97. I am a decree holder in a suit for eviction. The suit was decreed in 2010. The possession was given by the court's bailiff to me, my lord.
To you?
Yes. And then, my lord, the judgment debtor through its entity, my lord, related entity, my lord, had related entity had forcefully taken the possession back from us, my lord, and then filed an application
after DP.
Yes. Just before I take, my lord, to the impugned order, may I just give the brief background, my lord? My lord, I have given a list of date also. I shall follow the list of date, but before that, my lord, just a background of the matter, my lord. My lord, in 1980 September, my lord, one Raghuraj Puri, my lord, had, my lord, leased a triplex flat, my lord, very nearby, my lord, in Calcutta, triplex flat, my lord, to, my lord, the original defendant in the suit. Then, my lord, this original owner, Raghuraj Puri, had gifted these flats, my lord, to the appellant. The defendant, original defendant, my lord, they had accepted me as the landlord and started paying rent. Then, my lord, the rent was enhanced, they started paying rent to me, my lord. Then the original defendant informed in writing that they had assigned their tenancy to one of their sister concerns, my lord, who is, my lord, the present judgment debtor. Now, my lord, after, my lord, then they committed default in repayment of the rent, my lord. A suit for eviction. Yes.
The assignee.
Yes. For eviction was filed, my lord. The suit was decreed in 2010. Now, my lord, a section 47 application was filed in the execution proceeding, which was dismissed, my lord. I was given possession. Then, my lord, a second section 47 was filed through an entity saying that it's me, not the judgment debtor. This application also came to be dismissed. First appeal moved, dismissed. Then eventually, my lord, in 2021, a related entity comes up, my lord, and files
Another entity,
yes,
a third.
no, the related entity itself, an application under Order 21 Rule 97, saying that
The one who lost up to first
yes,
appeal.
no, the first appeal was the original defendant lost, my lord, the original. This is the related entity who comes forward and makes an application.
No, you said section 47 also twice was moved.
No, it was filed, my lord. There were two section 47 applications, my lord. Both were dismissed, my lord.
By? Both were at the instance of the same person.
No, my lord, no, different entities. All, my lord, controlled by the.
Therefore, we are saying this is by a third person. The first 47 and second 47 were by two entities.
Second really was
And
not
this is by a third person.
No, it's only second, my lord. Second was, my lord, they also filed a suit which they abandoned, my lord. Then they filed this application.
So it is that second person who is
yes,
filed.
yes.
Again.
Yes. But this time, the court allows their application, my lord. And today, my lord, despite the fact, my lord, that the matter, my lord, traveled twice up to the Supreme Court, and the court said adjudicate this on priority basis, my lord. The court has held that there were three triplet floors, my lord, three floors, my lord. There was an adjacent terrace, my lord. So eventually, well, what the court has held by this impugned order, that I am only entitled to the terrace, not the flat. Lord, I'll have to take, my lord, to the impugned order once, my lord, and show, my lord, that there are facts on record that would demonstrate, my lord, that these are all entities controlled by the original defendant, my lord. My lord, may I take, my lord, to the facts? My lord, I have filed a list of dates before, my lord. But I will on 20th January, my lord. This was, my lord, heard by another coordinate bench, my lord. It was fixed for delivery of judgment, my lord. And on that, Justice Tandon retired. My lord, was transferred to Cuttack, my lord. So, my lord, it has to be heard de novo, my lord.
How much time will you take?
This will take some time because I'm led by Mr. Mukherjee, my lord. But this is factually very heavy, my lord. I have to take, my lord, through the proceedings since 2010, my lord.
No, we are asking you for a purpose because see, from the first week of next month, we will not be able because of our determination in Jalpaiguri. So we don't want to start something and then keep it lingering for more than a month. There is a proposal that maybe this time the circuit will be for 3 weeks, maybe. So that will eat up almost 3 weeks of April. So there is no point in starting today. If it can be concluded within an hour or so.
Perhaps not, my lord. This will take some time.
Also, my lord, they have 3 applications under Order 41, Rule 27. Now, on 9th of March 2026, now there's a Supreme Court, the Supreme Court has passed an order where, my lord, that application perhaps would have to be decided, my lord, first before even they proceed with that.
No, it has to be considered at the final stage.
Yes, my lord, at that point of time, but these 3 applications, my lord, which are there, now it says, my lord, because, my lord,
the judgment only reiterates what is already decided. Nothing new.
Only different thing is, my lord, what they have been doing all this while is, my lord,
Not as a matter of course.
Yes.
When was it as a matter of course?
No, well, in this matter,
it was never as a matter of course.
Correct, absolutely. My lord, I bow down to you.
My lord, this has been specially assigned to your lordships, my lord. That's the difficulty, my lord. My lord, this matter has been assigned to my lords, my lord.
No, lord, I don't think, my lord, your lordships will be back from the circuit. It's not a permanent circuit.
The appellant is a 95-year-old lady, my lord. That's the, and I mean, really hard.
Therefore, we are saying,
over a period of time,
if you can maintain austerity, we can proceed. If you cannot maintain austerity, then we don't want to start and leave it.
I bow down, my lord. I follow.
Come back again, ask you to refresh everything. We don't want to do
because this is slightly fact-heavy matter, my lord.
Every my lord, court out here, my lord, has to go to the circuit, my lord, at some point of time or the other. So, Malad, if your lordships, Malad, is going on, Malad, obviously, Malad.
Because we have only hardly 1 week before.
That's very well, Malad.
Effective 1 week. So it won't be possible.
Then in that case, your lordship keeps it, Malad, after that.
What is your instruction?
My instructions are expedite, but we completely understand the difficulty is facing.
No, you can't say expedite and you can't say I'll take a long time, both at the same time. And who is to lead you in the argument?
I'm sorry, Malad.
Who will lead you in the argument? You are appearing.
But I am led by Mr. S.N. Mukherjee, senior advocate, he must be on his way, but this, as Malad has inquired, this might take some time, because they have to take through the documents. They have diverse litigations, since 2010, so may not be possible to conclude in 1 hour.
Where is Mr.
Malad can hear us today, tomorrow, and day after. If that, perhaps then it is possible.
Because we have many things we want to conclude before we leave. And with this now cannot take precedence over those matters.
Then Malad will kindly consider then releasing this.
We can do that.
So this has been specially assigned. We cannot.
This prayer, Malad, I am opposing and I am also not making, because I'll tell your lordship, there is a reason for this. On the last occasion also, I had indicated to your lordship, Malad, they've already filed an application. Malad, application before the Honorable Supreme Court. Malad, there, Malad, certain things have been stated, Malad. I don't want to reiterate what has been stated, but Malad will kindly not do it. Malad, I am opposing this prayer, then Malad, I'll...
What application they have? We don't remember what you said.
I don't think there's anything which Michael can indicate. Yes, please.
Malad, they should show, because it's their application. Let's kindly see.
It's not yet listed. I'm told.
Doesn't matter, Malad. It's filed. In the Supreme Court, we've been served.
This is only for expeditious. I'm told, Malad.
Kindly reads the application, Malad. I will not read it off.
This is in utter desperation, because we have been waiting for a very long time. This person is 95-year-old lady, who has obtained a decree 2010, and continues to be in possession, on one pretext or the other.
The matter was also heard by a coordinate bench, but unfortunately, on the day of delivery of the judgment, the honorable judge was elevated.
I've told that.
Malad, 3 applications under Order 41, Rule 27 has been filed.
Two applications there.
Case in the trial court, they did not lead evidence. They voluntarily did not lead evidence.
Anyway, this they will move before the apex court. This is not our concern.
But anyways, Malad, I am opposing, Malad, this prayer, Malad.
Where is Mr. Mukherjee? Mr. Mukherjee is coming.
I am told, Malad, he is in court number 25, Malad.
Sir, you are not proceeding. You want an expeditious hearing. So what are we to do, that we are wondering?
Malad, I can place, Malad, I can start, but the only...
We can't just while away time.
No, Malad, I will start placing the facts, Malad, but perhaps we'll be able to conclude within 1 hour.
You say that you are not to argue, somebody else is to argue.
I did not say that. I had just said I am led by a senior, Malad, and I can start, and in fact I had started also, Malad, but Malad, answering the query of the court, perhaps it may not be over in 1 hour's time, Malad. That's what I was trying to say. Nothing else, Malad. I can start, Malad, with the application, Malad. I have given a list of dates for my lord's convenience, Malad. I can start placing the facts.
Because we had fixed this today.
Yes, Malad.
Therefore, there is no scope for you to say that anybody is not here who is to lead you.
No, Malad, I am not saying that. I'm not saying, Malad, kindly takes up my appeal, Malad. I shall press my appeal, Malad. I'm not saying that, Malad. For a moment, I'm not saying that I will not press my application, Malad, my appeal, Malad. I can start doing my matter, Malad. My lord's hands, Malad. I can. Yes, my lord. My lord, kindly, my lord, takes the list of dates that I had filed, my lord. On 28th of January, my lord. Well, my lord, all the facts, my lord, have been summarized, my lord, with the reference to the corresponding page numbers, my lord. Yes, my lord. इधर आ जाता हूँ। List of date ना तो
I'm requesting my learned friends also to give us a copy with the list of dates.
दे दो, I'm referring.
No, we've asked from them.
I'm giving a copy, right?
They've refused, didn't write. See,
अरे दे देना.
This is what they wrote. We asked for it.
चिट्ठी दे.
Yes, yes.
Ask them to give the.
My lord, will this list of dates, my lord? Yes, my lord. It's on bond paper, my lord, I'm told. Stitched bond paper, my lord. But I have extra copy if my lord wants. My lord has it, my lord. My lord kindly takes, my lord. Serial number 1 to 17 are, my lord, facts which are pre-suit. And my lord will give the background for, my lord, before the suit had, my lord, started, my lord. And these are very, very important, my lord. The first, my lord, entry talks of, my lord, an indenture of lease of 1964, my lord. When, my lord, which was executed between Kumar Dharendra Malik and others. And Tinwald Properties, my lord, being the lessees, my lord. And my lord, this Tinwald Property was a partnership firm comprising of 3 partners, my lord, Swarup Prakash Puri, Ved Prakash Mehta, and Prithviraj Bakshi, where, my lord, this premises, my lord, where the building has been constructed, my lord, was demised unto the lessee, my lord. The term was 30 years, my lord. Then between 1970 to 80, my lord, the lessee, in the indenture of lease, my lord, constructed a multi-story. So, my lord, from 1970 to 1980, my lord, this building was constructed on this property, my lord. And this building is known as Trivoli Court, my lord. Serial number 3, my lord, will find in May, on 5th May 1980, my lord, the then partners of being the lessee, my lord, of Tinwald Properties, namely the said Ved Prakash Mehta, Prithviraj Bakshi, and Rajkumar Puri, my lord, Pradeep Mehta and Pradeep Raj Bakshi and Lalu Puri entered into a mutual agreement dated 5th May 1980, whereby, my lord, all the flats and premises were divided into lots, and by a deed of dissolution dated 1/7/1980, the partnership firm of Tinwald Properties was dissolved with effect from July 1980, and the investments were distributed. In course of such distribution and division, this subject matter of the suit, my lord, all that flat number 93 on 12th, 13th, and 14th of Block B was allocated to Raghu Raj Puri, my lord. So the suit property was constructed, flats were made, and upon partition among the partners, my lord, this subject suit flat was allocated to Raghu Raj Puri, my lord. Then, my lord, on 1st September 1980, my lord, an agreement to lease was signed between Raghuraj Puri, who is the lesser, to Lalo Puri, being the confirming party, and Arya Central Transport of India Private Limited, who is the respondent number 1 here, my lord. And the terms of the lease, my lord, were set out. My lord, this document, my lord, will find in the compilation, volume 1 at page 58 to 69. My lord, will see, my lord, the term of lease was 10 years. The rent was agreed to be 6,500 per month. And the respondent number 1 was allowed as to sublet, underlet, or otherwise parted possession of the property. Now, the subject matter of the lease was flat number 93. Flat number 93 on the 12th, 13th, 14th floor of the building, my lord. My lord, kindly, my lord, takes this document, my lord, which appears, my lord, at page number 58 of the compilations, first compilation, first volume, my lord, page 58, my lord. This is the first document, my lord, which will be of some significance, my lord, which we would rely, my lord. My lord wants me to run through the facts, my lord. I can run, or I can show, my lord, correspondingly the document also, my lord, if my lord so pleases, my lord. Then, my lord, on 1st June 1982, my lord, an agreement to lease was signed between Raghuraj Puri, the lesser Lalo Puri, and RA Central Transport Private of India Private Limited, my lord, in respect of another 10,000 square feet. The first one, my lord, was in respect of a flat. The second agreement, my lord, was in respect of a 10,000 square feet of 1,000 square feet of unfinished structure adjoining the flat number 93 on the 13th floor, my lord. So 2 agreements were there, my lord. One was a flat. The other, my lord, was 1,000 square feet of an area attached to the 13th floor, my lord. Then, my lord, the name of the said lessee, Arya Central Transport Corporation, my lord, was changed on 3rd December 1986, my lord, to Arya Central Transport Limited, which is now the respondent number 1, my lord. From 1996 onward, item number 7, my lord, will find the rent of the premises unit was enhanced from 6,500 per month to 13,000 per month. This was also decided by the Civil Judge, Senior Division 6, Alipur Report, Dictation number. I show the documents also. I'll have to come back to documents again. Very well, my lord. May I then run through, my lord, the relevant pages, the facts, my lord. My lord, at page 4. So then, my lord, Raghuraj Puri gifted the property, my lord, to the present appellant. And my lord, the deed of gift appears at page 486. How much I become the owner of the property. So, my lord, what's important here, my lord? What was gifted to me was the flat, the 3 floors, not the additional 1,000 square feet, which was separately given to me. Point number 1 by way of another. So, when it has noted, the 3 floors were gifted to me only. This is important. So when I was gifted with these 3 floors, the flat, and not the additional 1,000 square feet. So why this is important? Because I am the owner of the flat. My suit for eviction was of the defendant from the flat. What this impugned order does, says that I am entitled to the 1,000 square feet, which was never owned by me, which was never my subject matter of the suit itself. So this is important, my lord. Kindly takes, my lord, item number 8, Roman 3, which says the contents of deed of gift do not mention the terrace on the 13th floor, which was leased out to respondent number 1 by the lease dated of 1st June 1982, and is rather concerned with the flat number 93 on the 12th, 13th, and 14th floor, which was leased to respondent 1 with a deed of 1st September 1982. So this shows that the appellants have no connection whatsoever with the terrace on the 13th floor, which is adjoining that. Then, my lord, Item number 9 is the document which I intend to bring on record by way of additional evidence. Kindly note this document. It says it's a letter from the original owner Raghuraj Puri Miller to the respondent number 1. This letter Miller says that flat number 93 has been gifted to the applicant herein with a deed of gift of 14,1981. The respondent number 1 shall observe the terms and conditions of the deed dated 1st September 1980 as a deed. The letter has no mention of the deed, these deed dated 1st June, but only these deed of 1st September 1980, showing respondent 1 was aware that the flat number 93 on 12, 30, 14 had been gifted to the applicant, and the applicant have no connection whatsoever with the tenant. But what's important here, when I kindly note this, the 3 floors were gifted to me by the original owner of the property, and the original owner issued a notice of atonement to the respondent 1, stating that it's only the 3 flats which have been gifted to me. So I had no connection with this 1,000 square feet of flat, the terrace area which was adjoining to the 13th floor. This is evident from 2 facts. 1, the deed of gift which by which I become the owner, and a letter of atonement by the original landlord to the respondent number 1 company that the 3 floors have been given to me. When we kindly come to entry number 10, then there are letters, but these are letters of 3rd August 1993, 12th February 1994, 16th January 1995, 28th March 1985, 12th May 1995, 1995, and 31st May 1996, demonstrating that the respondent number 1 had been paying a sum of 13,000 against the terrace flat number 93. Demonstrating that there is a typographical error. It's this respondent number 2 instead of 1. Kindly correct that. So item number 10.
Page
20 to 26 of Can 2.
yes. So what is the correction? What is the error? Typography.
Page 5 of my list of data. 3rd line says respondent number 1. It should be respondent number 2. I am told it's correct. Correct.
Make up your mind. Yes.
So that by these letters, these demonstrate that the respondent number 1 had been paying a sum of 13,000 against the 3 floors where 13 14. This clearly shows that the respondent number 1 was aware and paying the required rent amount, not the adjoining tenants as objective was for that is the habit. Then will again the name of the company respondent 1 changes when on or about 1st October 1998, the respondent number 1 with effect from therefrom transferred its leasehold right in respect of flat in favor of the respondent number 2, and that by way of an undated letter, the same was distributed to applicant number 2, liability numbers. This letter Ian Arya and Sanjay Arya are ex-directors of respondent number 1 and are partners of respondent number 2. The respondent number 2 is now a unit of Car Infralog Limited. Mr. Ian Arya and Sanjay Arya are Infralog Limited and its promoters, and Mr. Sanjay Arya is presently one of the directors of Car Infralog. But what's relevant here is by this letter, the respondent number 1 was the original tenant. They informed that they had assigned their tenancy with respect to subject to property to the respondent number 2. This is an admitted proof. Their letter exhibited not in this. This is why the suit for eviction was filed against the respondent. original tenant was the respondent number one. Respondent number one assigned its tenancy.
First, respondent number one's name changed, and then he assigned it to respondent number two.
Now, respondent number two,
That is your case.
that would be evident from any help. One, entity number 1, 2, 3, 4 to clarify. On September 1981, these agreement was with others.
But you have just seen these dates from the. Why do we need to take?
Just for a
Not required. Yes, we don't want to add to this unnecessary. Yes.
is that page item number 12 and page number 5.
Yes.
Item number 13 at page number 6.
Yes, you just placed that.
Yes.
DN Arya and Sanjay Arya.
Now, DN Arya is a reference to this company card Infralog Limited by because subsequently after the decree was passed, this card Infralog also made an application saying that I have an independent right. Also filed a suit and abandoned it. But that's perhaps not slightly better. I should come to it later, but I just indicated because card Infralog is also a concern of the judgment data. I should show what card had done. Item 13, okay. That is quantum number 1, which effect therefrom transferred its leasehold right in respect to the device flat herein, and that by way of an undated letter, the same was intimated to the applicant, the one that is on 6 January 2020, bill issued by the respondent number 1 by Raguraj Puri for issuance of check of ₹500 being read for the month of January 2000 for 13 crore open terrace flat at the Holy Court. This document clearly shows that Raguraj Puri is the owner of the adjoining terrace and not the other, which is recognized as the number 1 as they continue to pay rent of 500 per month for the terrace number 13 crore to the flat. Then on 10th November 2003, bills issued by respondent number 2. Issued to respondent number 2 by the applicant for an amount of rent for terrace of flat number 93 for the month of November. But this document clearly shows that the applicants are the owners of the mine set. Recognized by the respondent. Then in December 2003, the respondent number 2 is also given to the applicant, and on 14th September 2006, number 70 filed, a notice to quit was given. By notice issued by the applicant, the tenancy in respect of the device flat was terminated, thereby calling upon the respondent number to deliver possession of it. This notice clearly specifies the quantum rate, that is 13,000, which further demonstrates from the fact that the same has been issued in relation to the flat number on 12, 13, and 14 1C by the user. Then on 23rd March 2007, the suit was filed. They filed a title, which was subsequently numbered as well. So again, the respondent previous asked regarding possession of that. The subject matter of the suit was flat number 93, where did not include the adjoining terrace on the 30th. Item number 90. On or about 10th July 2007, the respondent number 2 in title suit number 57 filed an application of order 711 of the court admitting that they are paying rent of as tenant of the terrace flat number 93. Then on 18th May, they filed a statement by the respondent number 2. On 27th April 2009, affidavit of evidence of service happened, PW1 was filed. 27th April 2009, the position of Sarosh Thakur as PW1 in suit number 57 19th November 2009 issues their frame, and 2nd December 2009 evidence affidavit of evidence of Feroz Thakkar was filed. She is the PW1. On 6th January, deposition of Thakkar continued. On 14th May, cross examination of Mr. Thakkar took place, and on 18th August 2010, the civil court senior division Aliku passed judgment decree for eviction, holding that there is no discrepancy as to the identity of property as scheduled exact the same as second schedule of this easy first September 1980. And should be observed one that order the or then the court orders the recovery of past possession. The court also ordered respondent to indicate the law, and the cost of this was imposed upon the act. Then I filed an technical execution on 25th November 2010 and 29th March 2011. The court believed by virtue of the report and possession of the property. This was from the respondent number 2. Then on 5th April 2011, despite recovery of possession of the building as opposite, the respondent number 2 posed itself inside the development plan and began to occupy the same again. On 5th April 2011, the respondent number 2 in the judgment defended in judgment that was referred as first. So, after having taking forceful possession, they also filed an appeal. The appeal was dismissed on 23rd March 2017. The division bench of the High Court the order records that the applicant number 2 immediately recognized the applicant that 1230 law and the demands that advocacy was transferred to the respondent. Therefore, there is no question should property not be the device plan of the respondent. However, the High Court modification doesn't get us to stand to vacate that enabling possession. For the record, the report of commission charge for the possession of the device. The present device yes, is the this is getting discharged when you transfer the file in someone. A review application was filed against the first on 11th August 2020. The review application filed with the judgment dated is one of the against the order of 23rd March 2020 was dismissed by the merits with the order of 19th December 2017. The holders filed an application under section 8 orders of the High Court and Bangalore for police assistance to bail as on 5th April. The judgment letter of certain case the demands that enforcement activities paid by this possessing. On 6 January 2018, the judgment letter is by an application paying for dismissal. Now, the degree is to be satisfied fully since the degree holder has recorded possession of received possession of demands that the copies against this application should also show that the respondent number 2 was in possession of the flat number 93 on 12/30 and handed over the possession to the applicant. Therefore, there is no question of the respondent 1 being possession. Then on 13th September, this is relevant because it was the respondent number 2 who had given the possession to the applicant. And now the respondent number 1 comes and says that I was all along in possession. And the suit and everything was happening behind my back. When the fact remains that the vacant possession of the suit property was handed back to the bailiff. If the respondent 1 would have been in possession, this was not possible. Court bailiff giving me possession is on record. Number 26. Item number 37. On 13th September 2018, the learned civil judge, Senior Division 6th Court, Alipur, after considering the objection made by the respondent to hearing, with an application of filed on 6 January 2018, dismissed the application filed by the applicant on 23rd June 2017 and 19th December 2017 by erroneously concluding that the same were not maintainable in their concurrent circumstances as eligible the execution in terms of the possession of the device that the applicant was already done. On 4th December 2018, Mrs. Sarosh Thakkar, one of the degree holders and the applicant of 1 million, referred a review application, revision application, issue number 464 before the Honorable High Court Calcutta challenging the order 13 September 2018. On 16 January 2019, the learned single bench of the High Court Calcutta allowed the revision application issue number 464, setting aside the order of 13 September and directing that the learned executing court to dispose of the application for instance of and directing the police to implement the execution within 1 month of the case. February 2019, letter issued by respondent 2 showing that respondent number 2 is the unit of card intra-law. Then on 8 March 2019, an application in this case was 41 in title execution 183 of 2010 was filed as a respondent. For the execution case was dismissed of 18th August we declared. But till this time, the respondent number 2 had contested. And this was dismissed. On 15th March 2019, the Supreme Court of India dismissed the special leave petition referred by the respondent number 2 judgment. The early judgment the first appeal was also afforded by the Supreme Court. Was the defendant judgment. On 15 July 2019, this is the fact we want to bring by way of an additional evidence. Resignation of Banwari Lal Sharma to the directorship of Card Infra Law addressed to the company from flat number 2093 flat law the said resignation was accepted by the central area road transport letter and the respondent to clear with a unit of card in front of it. This clearly shows that the respondent number 2 had been in possession of the demand analysis pursuant to the assignment of the right and that the respondent 1 was not present in the demand. Hence, the finding in the order 21st April 2020 that instead of the demise flat, the terrace portion of the 13th floor adjacent to the flat number 93 was let out to the is valid. On 16th September 2009, there is point number 1, 5 title suit, PS number 156 of 2009 against the applicant, and there is point number 2 alleged for the first time that it was an occupation of the demise flat all along, while the respondent was an occupation of only a small portion of the flat. The decree and the eviction, the decree and judgment of eviction dated 18th August 10th was obtained by court and the commission was not binding on it. On basis of such frivolous allegations, the respondent 1 attempted to seek an order of administrative injunctions on stay of execution of title execution number 183, but failed. The learned judge with the order refused to grant any administrative injunction and paid for by the respondent 1. Further, the case was dismissed for default by the civil judge, Unit Division, second court, with the order of 20. Then on 18th September 2019, the learned 6th civil judge, Senior Division Alipur, passed judgment in order dated 18th September 2019, dismissing the missed case number 41 in that case of 2010. The court also holds the issue of ownership regarding the matter when this application gets dismissed. 23rd September 2019, an application to this case number 138 of title execution was filed by one card installer. So another application filed by another system. Under order 21 to 97, 99, 100, and 101, alleging that it was in possession of the demise flat and paid for a stay on the execution. In the said application, respondent number 2, the unit of card infra law admits that the rent for the demise flat was 6,500 as 2,000, and that card infra law was in possession of it, which means the respondent was in possession of the flat. 25th September 2019, by an order of 25th September, this is the 138. The civil judge Alipur held that the respondent number 2 is a unit of card infra law and that the judge in the order noted that card infra law limited is another phase of central area road transport. Court recorded that respondent 2 is trying to initiate the card infra law rejected the prayer for state tax execution, imposed exemplary punishment for the cost of rupees 30,000 on card infra law. This order clearly shows that this contribution after participating for many years was trying to create on 27th April 2001, the respondent number 1 files an application under order 21/7/8/101. So another application, now this time by respondent number 1. Along with a stay application on miscase on the demise that is 13,000, while the rate of the adjournment is 5,500. It claims that the respondent was never in possession of the demise flat, but actually in possession of the adjoining terrace. When those opposite show the respondent can be paying to respondent 1 a sum of 30,000. with that applicant, they claim that this point number one is paying rent to renewable property for the device flat, even though it can be bought land activity. So they claim that the rent is paid to stable property which is to dissolve in 1980 and not to mutual payments. And they claim that there is point number one was the rightful tenant of the device flat and such and as such not found in the the risk case number 53 was dismissed because and the civil judge senior division election thereby it held that some of the directors of this one were partners in this and therefore the living person behind the respondent one and the respondent are the same. That was the finding of the court. It was held that the respondent number one is the respondent number two has filed multiple serious cases one after the other to delay the execution proceeding and to enjoy the device flat without being paid for charge. Because further held, the respondent one had complete knowledge of the decree and execution proceeding, and despite having knowledge for 10 years, the respondent number one had a petition the petitions of carbon limitation, impose exemplary cost of respondent agree and loss cost to the decree holders, and held that the execution proceeding cannot be run for an unlimited time at this order. End of it. This was an order path. There is an appeal from this one. On 17 January 2020, statute appeal number 5 of it was filed by the respondent one against the order of 15 January, which I just read. Now, by enclosing copies of the checks, bank statements, purported debtors of 9th January 4th December 2020, 1st January 2020, and 8th February 2021, the affidavit of documents on behalf of the applicant filed on the 21st that is point number one alleged that it had been paying rent in favor of now dissolved Bengal property. So it is to be noted that number one always aware as to whom the rent in respect to the device flat paid, that is to be affiliated and not in favor of the dissolved partnership. This was the case that the document on 14 July 2022, the degree holder applied the trial court to conclude the execution proceeding in 6 months' time. So this was filed against the order of the civil division that succeeded in. On 15 December 2022, in appeal number 5 of 2022, the appellate court set aside the order of 15 January, where in this case number 53 was dismissed. The learned appellate court directed the side this case. 11 January 2020, the learned civil judge civil division 6 court Alipur in tackling execution money directed the annual possession of the device flat by executing the writ on 26 June 2023. An appeal in second appeal tender 10 of 2023 was filed by the applicant against order 15 December 2022. The said appeal was dismissed as unpassed. In a second miscellaneous appeal, the Honorable High Court at Calcutta stayed the execution proceeding. On 20th February 2023, the degree holder filed a contempt petition having diary number 76 to the Supreme Court for counsel that wherein the time limit of 6 months was framed for disclosure of the execution proceeding. Already 24 times has been then comes the new order of 21st April 2023. The learned court disposed of in this case number 15 erroneously declaring that the respondent number 1 is the rightful tenant in respect of the demise plan and the decree passed in Capital 7 is not binding up. This is the order. And on 19th May 2023, the court in view of the order of 21st disposed of at execution number 180. 23rd September simplification by the fellow standard. Order of 21st April was 5 minutes. 23rd September to 7 September. Order by the High Court. On 11th December, the applicant for special petition against the order. With the order of 11th December, the Supreme Court allowed the applicant to 20th December, the applicant filed and received but these are the that I have to take over the applicant to the order by which the court allowed their application and held that they have an independent right. And I have to show them what is the material of the court proceedings part of the order. May I take over the
4/12/23.
which was April
20.
21st April 2020.
And what is 4/12/23? What is the date?
21st April 2023, that page 323.
21/4/23.
Yes, 21.
Page
324. Volume
2.
2.
Volume 2. What is the page you said? Yes. Me. He apprehends that it will take a long time. We're wondering if you could give us some with some level of, assessment as to how much time you will take. Because after 1 week, we will be in Jalpaiguri for 3 weeks, starting first week of April.
Immediately thereafter, will your motions are back.
Yes,
As a part this much I can say.
But the learned advocate was suggesting that we should release it. He said so in so many words. We said because it won't be possible to do it this side, the only option is he said, yes, you please release it. Because there is no way we can conclude it this side. You know it very well. Therefore, we were looking for you, but you were not here. He instructed him that it should be released. It is an assigned already. It is by way of assignment. So therefore, there is no question of parted. Either we proceed or we release. Because see, piecemeal doing it this side, then taking it up after another 4 weeks, that will be a pointless exercise.
Yes, we cannot conclude this side of over the second page. I will take this after your lordships are back. And whether
But there is some application which has been filed before the apex court, they are telling me.
kindly define requirement that we give instruments. They are limited submission. This application is free.
We don't, I didn't go into it yet, given it to us. So we have.
Before you take a
You are appearing for this side or that side? You. And who are you being led by? When should we fix it?
Not possible. 7 days.
You tell us. We are saying if you want, we can do it. But fix a time. Give us 1 or 2 hours. In 1 or 2 days, you conclude.
I think we'll take 3 hours and we'll be able to complete. Yes, because one full session on everything has taken up. Gives us that time. So all the factors, really fact having matters. That time.
this, I don't think I do not want to pushing further, and that is not my intention. Only thing is whether tomorrow there will be a shipment. Thursday, whether there is a preference and student, so we possibly have to rise by 3.
That leaves us with Friday only.
Friday, there is some uncertainty about whether
Maybe. We don't know for sure yet. We don't know for sure yet. Therefore, there is no way it can be done this side. So you give us an agreed date so that we can fix it for 2-3 days in a row and conclude the thing. Yes. We don't want to linger it for weeks together. Because then it becomes difficult for us also. If you could please agree to some date in between a week so that we can fix it over 2-3 days, then we can conclude it. Because there is a likelihood not yet decided that henceforward the circuits may be 3 weeks. It is in the process. We don't know yet. So if we are to go on 6th, we don't know whether it will be there till 17th or 24th. So it's better to fix after 24th. No, 27th. 9th, 9 to 11. 9 to 11. Or 11 to 13. So we'll give you 2 days in the second week of between after we come back, and then we'll give the other side 2 days. How can we? You tell us how it is possible. You make a submission for the sake of submission, that we understand. But you tell us that it is possible. How can we? We can't leave everything aside for this. Those matters can be just simply set aside. This is an assigned matter. We can't abort the board for this and for days together before we leave. Is a Monday. This side, March, it will not be possible. Simply can't conclude. No, what we were suggesting is we can have it 3 days in the next week after 24th, 2 days for you, and then they can start. We can have it on 29th, 30th. 29th, 30th for you. 2 days, please try to wrap it up in 2 days. And then Mr. Mukherjee, the parties have made you will see our list every day we have fixed because we are dealing with 5 different subjects. We can't abort everything. Yes.
Number 27.
Oh yes. That has been implemented. That has been implemented by you.
Yes, already I talked with Mr. Kisha.
No appeal. Yes, we were under the impression that appeal has gone, but there is no appeal. Later, we found out that they are in the process of perhaps implementing your.
The last profession you actually wanted to see the government in power in questions of law.
We will, no. You are aware that a certificate of disability is issued under the Act and Rules, PWD Acts and Rules.
But the board which has certified.
Sir, just a minute. We have also done some research in between the last day and today. No, that is under the person with disability rules.
But prior to that too, when my lord wanted to know whether there is a government any notification issued by the competent authority to refer to the medical board in case of disability. If employee.
There is a notification.
Yes, a notification.
We have seen it in one case.
It's a notification of 1993.
Yes, we have seen that one. Yes.
After that, kindly see. After the act came into force, the state government, central government issued a notification empowering the state government to make the notification.
Correct.
And certify.
Correct.
Kindly see that. Kindly see that. Mental illness, page 3. Here from the medical board, for medical assessment available in the website. History of total justice empowerment process. Persons of Disability. Government of India has enacted the right of persons of the Disability Act 2015. Thereafter has notified the guidelines for assessment and certification of the specialized disability. Including the right of the persons with the Disability Act 2005 notification dated 4th January 2018. Now in persons of paragraph 57, that the following authorities and jurisdictions within the such certifying authorities shall perform the certification functions are mentioned hereunder. The certification of the different categories disabilities are different will be as follows.
What do you want to tell us?
Disability certificate issued by the board not under this statute. And disability certificate has not been produced before your lordship. This is under the notification of 1993.
Yes, because it is prior to this.
No, this act has not been given retrospective effect.
There is no objection by anyone that this is not a certificate issued in accordance with law.
No, if he wants to take advantage of.
There is no objection by anyone. Your objection is only that at the time of medical certificate of fitness, you found his degree to be varying. You don't say that that certificate is not in accordance with law. That's not your case.
No,
that you can't say here.
Can you see 1993 notification?
That's why we are saying for what? That's not your case.
No, why I'm saying?
That is not your case, in fact. Where is the impugned order? Read the impugned order, what it says.
That he has not qualified 60 years because he had left about 59 years something. 1 year something left.
60 years.
Retirement is 60 years.
Yes.
He must have 2 years service before retirement. This is the only issue before the tribunal. And he has not challenged the medical certificate or disability certificate. His contention that I have been declared by disability under the Disabilities Act.
I applied 2020. March, my lord.
How that issue is arising? Who is
Can you see the language? 1993 rendition. Direct to state that the benefit of the offer of employment on compulsion ground to a son, daughter, near relation of an employee retiring prematurely owing to being disabled, permanently or otherwise incapacitated until continuous service available if any only if such employee fulfills the three calling conditions. Premature retirement, he should not be entitled to full pension benefits to which he would have been entitled to which he has retired at his normal age of superannuation. He has fully exhausted all kinds of leave, computed leave on medical grounds. This is the very important. This has been given to him. He has 2 years of service or more left to reach the age of superannuation. This is the condition. And then your can see paragraph plus sentence. The whole process should be completed within a period of 90 days. Time limit, your lord. Last occasion, your lordship asking whether the time limit has been fixed. Time limit fixed 90 days. And my lord, application 4th September 2020 and ordered to the medical board 11th December 2020.
What is the order date?
4th September 20.
Application.
Application made by his wife. Then it was forwarded to the medical board 11th December 2020.
When it was fine, when he was declared disabled, when the medical board was conducted.
I find from my 31st August 2021.
31st August 2021. So how much beyond 90 days it is?
No. Within 90 days, it has been forwarded to the medical board. If it is forwarded, it has to be forwarded within 90 days from the date of the application. And this certification, disability certificate, not by the authority under the Act of 2016. This is under the executive order of the state government.
The whole process should be completed within everything.
Then can you see rule 18.3 on a form? No, the form.
So whether we go by this or we go by the rule, in any case you are way out of time.
No, but assuming for a moment this is out of time, but certificate has to be issued under form 5, 4 and 5. There must be an application under the form 5 of rule 8.
That's not your case. There is no case like this.
There is no such pleading. No such pleading.
The only thing you say is that the declaration is at such a time that he is falling short by so many days.
Yeah.
You never said that the certification is not in order. You never said that it is by an incompetent board.
No.
Nothing. You say he is just falling short. You accept that he is disabled. but you say he can't get this benefit because there is so much deficiency in terms of days. You cannot dispute the certificate.
Because
You have not done so.
Can you see the language? Small a, Roman 3. He has 2 years of service or left to reach the age.
So that is only your case.
Only.
There is no case that certification is not in accordance with law or that it is not by a competent authority. There is no application. No such case.
No, there is
You are
no such
only saying there is a deficiency in number of days.
number of days.
That's all.
But it's
Now, who is responsible for that deficiency? That is the issue.
Yes.
Whether he can be thrown out because of that deficiency or he cannot be.
he can get the benefit of the 2016 Act, provided there is a certification.
There is no question of 2016 Act. The question is if we go by this also, forget about 16 Act.
Yes.
If you have not done within 90 days, who will suffer? That is the only issue.
That was not challenged, but that was not, he was not taken before the court.
No, we are asking you.
But the question of fact is not.
It's not a question of fact. It is an admitted fact that the certification is of 21, 22 and application is of 20. There is no dispute. There is no dispute regarding this fact. Yes, you have admitted. There is no question of any dispute. So who is responsible for this and who should suffer? Whether he can be made to suffer.
But that.
Come to your affidavit in opposition. Where is your affidavit in opposition?
Paragraph 3 onwards.
Yes.
Date of birth, date second. From the medical report submitted by the medical superintendent of Vice Principal of Medical College Hospital, the official director came to know that was at the declared completely incapacitated, partly incapacitated from the service from 31st August 2021.
That's all.
There are considering the situation and verbal discussion with the picture, the office of the collector decided to offer the best financial support to the distressed family of Sri Ulu Ghosh and plan all possible help already distributed. From the records we found that as per decision rules, one can be the from consulting service with 24th August 22, thus found that 58 days extended service period entitled for another 30 days of early, thus the service should be further extended till 23rd September 24. That she goes difference between premature retirement and the factual date of retirement of 31st August 24 comes to 1 year, 11 months, 9 days with 6B of the Labour Department circular. When a Labour Department circular proceeds, there must be at least 2 years service is necessary. But 1 year, 11 months, 9 days.
That is the only case. There is nothing else.
And his case is not that because under the 2016 Act, this is by certificate.
Forget about 16 Act. Forget about 16 Act. We are not asking. We are now relying on this which you have given us.
Yes.
Now we will rely on this, which says everything must be done within 90 days. When you have laid down a time limit and you exceed that, he will suffer. Forget about 2016 Act. Everything must be completed in 90 days. The entire process from recommendation to constitution of the body to submission of report to the administrative department, everything within 90 days.
But until unless medical report comes, but can't government.
Correct. Then until and so then therefore then the question arises, what is the hurry in doing it in within 1.5 years? Why don't you take another 6 years?
No.
Then that question arises. Why such a hurry to do it within 1.5 years? When medical board will be constituted? When means whenever.
No, we have forwarded in time.
You have forwarded from one hand to the other, not to some other person. Who is responsible for that?
To the medical board.
Who is responsible for that? You are responsible.
No, we can send the medical board.
No, you can do everything. You are a state. You can do everything. It is not that you have sent it to a private
But
individual.
certificate authority is not before your lordship.
Not required to be. You are here. You are not casting the blame on anyone. You are saying because his day is short. You are saying his days are short, therefore he will not get it. There is no requirement of anybody else being
In
here.
my export submission 2016 Act does not apply.
Again and again you are saying something, we are saying forget about it.
Yes. But an
Forget about it. Why this 90 days has not been complied? Why you lay down such a procedure for 90?
Separate authority. I'm not.
Yes,
board is not
yes.
before your lordship.
Very well, very well. We are not concerned with the board. We don't want the board to answer anything. We want you to answer. That if you have laid down a procedure to be done in 90 days, what you have done nothing.
No,
How he can made to suffer?
no, but he could have immediately, there could have been a prayer that this certificate has been delayed. There
Yes,
was such prayer.
correct.
There was such pleading in the.
He should be chasing everything and you should be doing nothing. Just issue a circular that it has to be done in 90 days and then go to sleep. Very good.
And the issue of the judgment of your lordship case of
See, again and again you are saying that we have already said forget about the 2016 Act. Forget about it.
so far as Devika Karmakar, for initial appointment. Because section 34 provides that 4% post should be reserved for the disabled candidate. My lord has dealt with that, Devika Karmakar judgment. If certificate was issued under Rule 18.3, certainly he will get the benefit of disability provisions.
Any guidelines has been issued under 56 by the state government. '56 and 57 both. Guideline must have been issued.
Yeah, this is the, that's how.
You have given us. This one, this is of 93.
180. 57, under section 57. To your border and section 58. Incapacitation has not been defined under this act, only disability.
In DCRV, they use the word incapacitation.
Incapacitation.
Where is that?
Can you see the 93 notation?
It says disabled permanently.
Incapacitated, otherwise incapacitated.
Read the first paragraph.
In partial modification of the Labor Department Circular number Sasanjaj, Labor Department Circular number Sasanjaj, and directed the benefit of offer of employment on compensation ground to a son, daughter, near relation of an employee retiring president owing to his disabled permanently.
Yes.
Otherwise incapacitated.
Correct. So it is used interchangeably. There is a stroke in between the two expressions.
Can you see the
Disabled permanently or otherwise. So both.
But 2016 Act, incapacitated has not been defined.
Not required. Not required. He has been disabled permanently.
Disabled permanently for rendering service.
Correct. And that is what this is issued for. This is not issued for anything else. This is only for that only. And how it will, see, after the act has come to occupy the field, how this will continue?
There is no challenge, brother.
Not required.
There is no argument. There is no pleading.
That's not required. That's not required. We can rely on this also. The result will be the same. But the point is, once this under 57, you have already issued a guideline or a procedure. You have done it.
Who is the certifying authority? The board for
Only for that.
Only for that.
Come to clause 5 of this order of 29/8/18. This clause 5.
As laid down in Rule 18 of the parcel, the after declaration certificate of disability form 55678 given to the applicant is found to be medical notice convey the decision in writing to form 8 within a period of 1 month.
1 month. Twice it says 1 month.
Certificate of disability 18 and form 17.
Yes.
The kind sheet. the applicant is found eligible for, medical authority should after due examination, permanent certificate of disability, on receipt of the application under Rule 17, the medical authority or any other local authority verify the information provided by the applicant and shall assess the disability terms of the relevant guidelines by the central government and thereafter satisfy himself the applicant is a person with disability certificate of informed 4, 5, 5, 6, 7, and 8 years facility shall issue the certificate. Can you see form 5 and 6 at page
Form 5 and 6. It is there in the guideline that you have given us.
Yes.
It is there in the guideline.
Huh?
It is here in the guideline. Form,
the guideline.
Form 5 is, it is there in the guideline. Form 5 is there, certificate of disability.
Yeah. Who can apply? Application form 4 on that page 80 of the book.
4.
Can you see the book? Yeah, application for certificate of disability or persons with under Rule 17(1). If this application was for under the form 4, then he could have get the advantage of 2016 Act.
Correct. No, the issue is whether after coming into this act and the guidelines, how this will survive. This cannot be made a basis. This can.
But 2013 circular must have 2 years. That is there.
2013?
That EMP, Appointment on Compulsion Ground scheme. Scheme.
No, that is also prior to this 2018 guideline. So that certification of being permanent.
That's not mentioned in the 2013 circular. Only in 2000 after very much searching, because this all are not available.
No, this I have seen. I had seen it on the internet when I was dealing with that Devika Karmakar case, because I was wondering where the certification was done under which provision. So I had seen it.
After gave much trouble to my officers, I could from the department could.
And after I took all the trouble, then you are saying. I've seen this. This was prior to the 2016 Act.
Yes. And 95, even about 1995 Act. Because 2016 Act repealed that 1995 Act.
Because that EMP must have incorporated that provision because of the provisions in 95 Act. 95 Act also there was a procedure.
No, there is no, only that 3%, now it is a 4%. Initially, the 3% post be reserved for the disabled person. And but so for a child with difficulty, there has been discussed, all positions have been mentioned there. And government issued a circular. In all admission to any medical students or students in any college, 3% students should be given preference as a PH candidate.
16 provisions are much more detailed. 2016 Act.
Yes,
much more detailed.
16 Act detailed discussion has been made.
Yes.
And rules have been. Because and under this legislation has been made by the Parliament under Article 253 of the Constitution. Because it is under Article 253 of the Constitution. Because it is under the international treaty. Last, when a Beijing Declaration 95, then in another declaration. No. Beijing Declaration made, Beijing Declaration, according to the Beijing Declaration, 95 Act was enacted. Then another international treaty was that India was a signatory. Then this Act was amended.
All these acts are
with the power of the domain of the Parliament.
Yes.
Except Parliament, nobody has any power. No. Under Article 253, only Parliament has got power. Because the international treaty is there.
It refers to 253.
Yes.
In the Act.
No, can you see the 253 of the?
No, that we appreciate what you are saying.
United Nations General Assembly.
This will fall in which list?
253. Article 253, not 246 or whether 254. 253. No, neither list one, list two,
Neither
only.
state nor concurrent, he is saying. He is saying neither union nor the state nor concurrent is under 253.
253, that means
To give effect to an international treaty.
And this convention of 2006 and when it was ratified on 1st October 2007 by the United Nations. Designation for giving effect to the international agreement. Notwithstanding containing any foregoing provision, chapter, Parliament has the power to give law for the whole or any part of treaty or agreement or convention with other country or countries or a decision at the international conference, association or body.
But that legislation will be brought about under 246. This is the power under 253.
No, but 246, list one, list two, list three.
List one also includes United Nations and treaties.
Yes, 246.
List one includes treaties, international.
Yes, list one.
Yes. So therefore, the legislative power will be exercised under 256.
But whether the central government can make any law to appointment and compulsion government in a state government in a federal structure.
No, it's not a. That's not the issue. We are talking about rights of persons with disabilities act.
Yes.
We are not talking about compassionate.
There is no dispute. This is a legislative competition with the parliament. And parliament made the law. And according to the parliamentary law, state government issued a notification.
Therefore, when the certification of a disability is to be prescribed by central legislation, then
certification, then there must be an application.
Correct.
There must be an application. Can you see the form 5 and 4? There must be an application.
There must be an application. There was an application. There is no dispute that there was no application.
No, there is no application in the form 4.
Nobody has said so. You have not said so. It is not your case, sir.
No, but if he wants to get the advantage of 2016 Act.
No, he wants to get advantage of your EMP. But he wants to get advantage, or maybe he is entitled to advantage, maybe not. Under the Act, that certification is to be done within a time. It is not at the sweet will that you will keep it for 1.5 years and say he didn't do it, he didn't do it, he didn't do it. It is your responsibility. You have made the regulation.
But that point was not agitated or stated in the original application or anywhere in the requisition.
There is no dispute that there was a delay on your part. There is no dispute. You don't dispute the dates. That application was made in August 2020 and it was finally allowed after 1.5 years.
No,
that is so many words you have said in your opposition. You have stated the dates.
Application 4th September 2020. That lady that my husband is See,
And when see your opposition, the dates you have mentioned.
now page 3, Roman 2, on 4th September 20, the rich petitioner Srimati Sujata Ghosh submitted a prayer before the collector in charge of Kolkata, stating that facts of illness of Bulu Ghosh regarding his abnormal behavior due to mental depression along with it. As soon as these days, when the government is duty to forward his application to the board, that is within 33 months he had been forwarded. But the board took some time, has not forwarded.
So very well, you are relying on this.
Yes.
There are two cases. Who is in the other case? What are the? In the other case also opposition has been filed.
Yes.
What is the statement in the opposition? Let us see. 190. WP.ST 190. Date at last line of P appears to be incorrect. Huh? Perhaps 17. 17. The report of the three examinations, have you placed it on the? There are the three reports. Or page 23. No, where are the three certifications? No, there is one of 24th January 18, 11 July 18, and 29th August 18. Where are these three? There. Where are you, sir? We are considering your case. You don't know what is going on. We are asking you where are the three the three reports of 24th January, 11 July, and 29th August.
Number 50. 46 and 40.
45, 46. Annexure C. 45, 46 and 49. In this case, where is the order of rejection? Page. Page 80. Annexure J.
State legislature.
Huh?
These two, seven schedule, entry number 31. Of the state government. Entry number 41.
No, this is something else. We are talking about the disability aspect, not the service aspect.
No, what that 96 circular issued under Article 162. State legislature have got power to make laws, state services. And that's why 162 power, if the state legislature have got power, then we have got the power to issue that circular.
No, we are only concerned with certification regarding disability. We are not talking about that is obviously your prerogative. Public service is under the state. You are the competent person. Whether you do it under proviso to 309 or you do it 160, that is that we know. That is not a problem. Now we can't do it right now. What will do? That's when to keep it. We have heard everything. Just want to see the last order, the rejection order. Yes, page 58. On Monday. For further consideration list.